What began as a routine plea hearing quickly took an unexpected turn. The defendant hoped to resolve his case through a plea agreement, but one detail stopped the entire proceeding. As the judge reviewed the case, serious allegations involving a pregnant victim raised concerns that would change everything.
Injury whatsoever. This is really, as far as I'm concerned, on top of that, this is frosting on the cake. We've got a child here who's 3 years old that had just been scorned essentially by his father, in the sense that, and I don't mean scorn, but told, I don't want this ice cream sandwich, and his feelings were hurt, and the victim testified to that. And yet a few minutes later, she's telling the police, Mommy hit Daddy in the face. There's no contrary evidence to support anything other than the fact that this assault did not occur. She also stated, please do not arrest me. I don't know why somebody would say, please do not arrest me, when they were the victim of an assault. So under no circumstance, honestly and truly, this is not a close call for me. There's no way the prosecutor proved her case beyond a reasonable doubt. You did a really good job, Ms. White.
Judge, I appreciate it.
And Ms. Holloway, you are going to be one remarkable lawyer. You've only been practicing how long?
Almost 5 years.
Well, you are going to be a really good lawyer. I love your demeanor, and I think you are going to be judge material. I find the defendant not guilty, and again, this is not really a close call. So,
Judge, we appreciate
you're discharged.
Thank you, Your Honor.
Thank you.
Rule 6.419 AC. Looking at a light most favorable to the prosecution without weighing the credibility of the witnesses, it is our position that the trier of fact cannot find that all of the essential elements of the offense of domestic violence have been proven beyond a reasonable doubt. Mr. Kennard is charged with domestic violence contrary to MCL 780.81 subsection 2. Number 1, pursuant to the criminal jury instructions, the people would have to prove that Mr. Kennard assaulted Miss Bonnie Stewart. Number 2, that Mr. Kennard is her spouse. Pursuant to the criminal jury instructions 17.2a, the essential elements would be, number 1, a battery is a forceful, violent, or offensive touching of a person or something closely connected with her. And number 2, the touching must have been intended by the defendant, and an assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit the battery or make the complainant reasonably fear an immediate battery. Your Honor, it is our position that the people have not met their burden. Factually speaking, and pursuant to the jury instruction, there is no evidence. Pursuant to 17.2a, there is no evidence of a forceful, violent, or an offensive touching on this record. The complainant admits to no injuries, no medical attention, no physical evidence of any touching, let alone a forceful, violent, or offensive touching. Your Honor, a forceful, violent, or offensive touching would have physical evidence of injuries. The complainant admits the entire alleged incident takes place on either audio of hers and his audio and video recording. So the court has been in a position to, at minimum, listen to the entire interaction. Specifically on his recording that the complainant objected to on the witness stand, he says, Bonnie, you have twice lunged at me trying to grab my phone and screamed, I hit you. She replies on the audio video recording, no. He's telling her to get away from him at least 24 times. both before and after any alleged assault. She threatened him, and if the court remembers, in a very calm voice, she says, "I'll call the cops." He tells her point blank.
This is the moment the courtroom shifts from legal procedure to personal accountability. Instead of focusing only on the charges, the judge asks a question that forces the defendant to see the situation from a completely different perspective, one that no parent wants to imagine.
Either communicate with her or provide him with his phone. And this takes place after the alleged assault. The second witness, Sergeant Canterbury, testified as a sergeant and a supervisor that he completes detailed written reports. The complaining witness claimed that, according to Sergeant Canterbury on the scene, that Mr. Kennard struck her one time on her right forearm. The forearm, he testified, is the lower portion of the arm. The complaining witness testified on direct examination when either the court or the prosecutor questioned her regarding the positioning on the arm or the portion of the arm where he's alleged to have hit her. She testified the upper area of the arm or the tricep. Lastly, Your Honor, the defense admitted Exhibit 2, Sergeant Canterbury's body-worn camera. After the fact, she asked Sergeant, "Please don't arrest me." After the fact, when the police are on the scene, she doesn't cry or become hysterical until her husband is being arrested for a crime that he did not commit. Thank you, Judge.
Thank you. Any response?
Yes, Your Honor. Your Honor, when considering the motion for the directed verdict, the court must consider the evidence in the light most favorable to the prosecution. Now, defense counsel did just lay out the elements for domestic violence. So in this case, we do have to prove that an assault and/or an assault battery occurred under the statute. And the prosecution does not need to prove injury in this case. And although we did not see any photos of injury, we did hear testimony about an injury. In addition, we heard testimony that the complainant was terrified of the defendant, Stephen Kennard, and he also saw body cam and police Sergeant Canterbury's testimony that he observed Miss Stewart afraid and blinking and darting her eyes, indicating that she didn't want to be heard around Stephen Kennard. Again, under the statute, we need to prove an assault and or an assault and battery. And
You know what? I thank you very much. Taking all the evidence in light most favorable to the prosecution, the court finds that a reasonable fact finder could find proof beyond a reasonable doubt. There is still testimony as to whether or not the defendant battered the victim. There was testimony from the victim that she was struck in the arm. There is a dispute, obviously, with regard to where that would have occurred. I acknowledge that there were no injuries. However, an assault and battery does not require an injury. So I'm going to deny the defense's motion.
Yes, Your Honor. May we call our first witness?
You may. Thank you.
Officer Luis Hartado. He's an officer. Yeah. You might want to get up. Okay, thank you.
I'm sorry, who is this? Officer who?
Last name spelled Hartado.
Oh, Hurtado. I believe it's Hurtado.
Sorry, Judge.
That's okay. All right, sir, you can come right up here, please. And I'm going to ask you to raise your right hand. You solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, sir.
Okay, have a seat, please.
Good afternoon. So will you state your name for the record?
Officer Luis Hurtado.
And are you a police officer with Roseville Police Department?
Yes, I am.
And how long have you been so assigned?
4 years, I believe.
Okay. And on this particular day, 04/03/2026, did you respond to a scene?
Yes.
And was it on the street Canterbury?
Yes.
Okay. And when you arrived on scene, did you have a body camera
Yes,
recording both audio and video?
yes,
And you don't have a written police report in this particular case, is that correct?
I do not.
And Judge, may I approach, I would like to mark the officer's body worn camera as defendant's proposed exhibit 3.
You may approach.
Thank you. I am approaching you with what has been marked as defendant's proposed exhibit 3. And I'm not gonna play it, I just wanna, do you see something on the screen there?
Yes,
Okay, and I can play it, I need you to identify, is that your name at the top?
it is.
Would that be your body cam?
It should be. Yes.
And it was functioning on that particular date and at that particular time?
Yes.
And Judge, I move for the admission of this officer's body worn camera.
Any objection?
No objection.
Defense 3 is admitted.
Thank you, Your Honor. When you arrived on the scene, did you encounter the complaining witness in this particular case?
Yes.
Okay. And did she express to you what her desire was regarding the arrest of her husband?
I don't recall if she specifically said something to me. I'm sure she did say something to my sergeant.
Okay.
Sergeant.
And would reviewing your body worn camera that has been admitted into evidence refresh your recollection?
Yes.
Oh, thank
By the way, I record all these. I didn't this morning, but I told them to go on, so you're on YouTube for whatever it's worth.
Okay, thank you, Your Honor. Thank you. May I approach the witness again?
May.
Thank you. Or, you know what, the microphone is here, so, well, I don't know. I'm gonna play 7 minutes at the 7-minute and 32-second mark.
Controller to now right now.
Slow down. Can you turn that up a little bit, please?
Sure. I think I'll do what the prosecutor did and stand by the microphone.
That's fine.
Okay, thank you.
You took the microphone to the speaker.
Like this?
Just bend it towards your eye patch.
Oh.
Yeah.
So sorry. Thank you. Did you hear her say that on your body worn camera?
Yes.
Did you hear her say, I don't want him gone, I don't want him arrested?
Yes.
Does that refresh your recollection, sir?
Yes.
Oh, okay. Now, did you have contact with another individual that was inside of the location?
Yes.
And who would that be?
It would be the son.
Okay, and do you recall the son's name?
At this time, no.
And if I suggested Stewart,
Yes.
it is Stewart, okay. And how old is Stewart, if you recall?
That I do not remember.
If I suggest to you that he's 3 years old, would you?
Maybe I don't remember asking, but I may have.
Okay, no problem. And can we agree that you had communication with Stewart, is that right?
Yes.
And do you recall, Stewart making any volunteering any statements to you?
Yes.
Okay, and in fact, what did Stewart say to you when he volunteered?
Right before we were going outside.
Yes.
To go play with them. He said that mommy hit daddy in the face.
Okay, I'm gonna play something for you.
So, right now?
Did you hear that?
Yes.
Is that what you were referring to?
Yeah.
And so, is it fair that you didn't ask that baby that question, did you?
No, I didn't.
Okay, so did the baby just voluntarily say that to you?
Yes.
Okay, I'm gonna play something additional. I want you to listen to it. This has been admitted, and then I ask you a question, okay? Was that you? Was that your voice asking Stuart, and then what happened?
Yes.
Okay.
Mom is very extreme.
Did you hear what he said?
Oh, no, not actually.
Okay, I want to play it again. I want you to listen and tell me if you heard him say, mommy was yelling and screaming. So I want you to listen for it.
So what happened first?
Sorry, let me take you back, okay? This is a little hard. Now, hey, okay, it's got.
What happened? Back. No idea? Okay. After mommy hit daddy in the face.
By the end of the hearing, the court had made its message unmistakably clear.
Who hit first? Was it
Violence
mommy or
carries
daddy?
lasting consequences, and protecting
Mommy hit
victims
daddy
remains
first.
the highest priority.
Okay.
The sentence was designed not only to punish past actions, but also to prevent future
Were you
harm
watching the whole
and encourage real accountability.
It is dirty. Yeah. Were you? Yeah, it does have to run. Were you watching the whole time, or did daddy hit mommy first? Daddy hit mommy first?
Did you hear him say, I'm telling daddy? Yes.
Daddy, yes.
Yes.
Okay.
It's sure. Did daddy hit mommy first? Mommy did?
I'm sorry, Your Honor.
You want to drink one?